Welcome to another Three Steps to Startup podcast brought to you by Tech Connect West Virginia, Innova Commercialization Group, and the West Virginia Jobs Investment Trust. This is Jeremy Turner from Epic Mission, where we are guiding the heroes of change, and I'll be your host. This podcast is part of the Three Steps to Startup initiative. The goal of Three Steps is to provide early stage entrepreneurs with critical assistance and structured guidance for innovation commercialization, from ideation to product launch and market entry. Three Steps to Startup is made possible by support from the Appalachian Regional Commission and the Claude Worthington Benedum Foundation. Today's podcast is one in a series in which listeners will have an opportunity to drop in on conversations with industry veterans and subject matter experts who offer deep insights and actionable intelligence to help entrepreneurs launch and grow their ventures. Today, we have Scott Ewing with us for another visit. Scott is the co-founder and primary business analyst in the Appalachian Investors Alliance, or AIA. As we learned in our last podcast, AIA is a nonprofit that facilitates greater access to angel and venture capital for entrepreneurs throughout our region. Scott, welcome back.
Thank you, Jeremy. Happy to be here.
So Scott, last time you ended by letting entrepreneurs know that investors will look carefully at their company's technology strategy during due diligence. Due diligence, as we know, is just a term for the research and analysis that goes into making an investment decision.
That's right. What I was saying was investors know the odds are so much against any one patent or patent technology having commercial value, which means that a patent technology is unlikely to earn enough to pay back the total cost for the R&D that went into the technology and commercializing it into a product and marketing and distributing the product.
So as I recall, you gave the probability as 1 out of 3,000.
1 out of 3,000 raw ideas. The odds are slightly less than 1 to 100 for issued patents. So take that in. Less than 1% of patented ideas have major commercial significance. And those numbers come from the Industrial Research Institute, by the way, and they've been correlated across a number of data sources, including laboratory patenting, corporate activity, independent inventors, venture capital. So I stress the major commercial significance issue because if you've looked at angel or venture fund portfolios, you know that 50% of early stage investors' investments are likely to fail, meaning that investors will lose most or all of their investment on those. And another third or so will break even. So the odds are that just 1 or 2 investments out of, say, 10 will need to pay for all the losses and then make an adequate profit to compensate the investors for having taken risk. And these numbers are, again, backed up by research. So the Angel Capital Association and the Kauffman Foundation have put quite a bit out on this.
Okay, Scott. So when we hear that angel or venture investors are greedy and only interested in funding deals that can pay them back 10 times their investment, it's more true to say that they're trying to cover their losses by selecting deals with the greatest individual upside potential. Is that right?
That's right. Yeah, it's simply following a rational investing strategy. Some call it swinging for the fences, but if an investor isn't trying to score home runs, they're going to have a difficult time remaining active in their community since their portfolio is likely to implode from the accumulated losses. When it comes to looking at patent technology, investors want a reason to believe that a company is building its business on IP that's commercially valuable. It's unlikely to score a home run otherwise.
Okay, well, how can an entrepreneur or investor know that a patent may be valuable? If only 1% of patents will pay off, it seems to require luck more than anything else to pick the right patents when forming a company. Is that fair?
I'll answer that, but let me return first to my insistence that a company needs a technology strategy. A business partner gave me a good definition of technology strategy, so I'm going to give it here to you. It's a specific, measurable, time-bound framework for making decisions about technologies which are applicable to the business and decisions about resource allocations between technologies. And I know that's a bit heavy, so let me unpack it. A lot of startups provide us with project management waterfall or Gantt charts showing when certain events are expected to happen with respect to commercializing intellectual property. That's fine, but that's not what I mean by having a technology strategy. Technology strategy lays out the reasons why a company needs certain elements of intellectual property. Those could be patents or trade secrets or copyrights or licenses, whatever. The company maps out how those elements of IP support their core business. Sometimes it's a patent that's foundational to creating a product. Other times the IP isn't required to build a product, but may be useful at creating a defensive moat around the company's business. So in the first case, the company may depend on a composition of matter patent. It's very important. And in the second case, the company may want a method of use patent that prevents others from using the composition to do certain things.
Okay, so a composition of matter patent might be a chemical formula. The method of use patent would cover what to do with the formula once it's produced.
Yeah, exactly. So let's use an example. Titanium dioxide. I like to use this example a lot. Titanium dioxide is manufactured into all sorts of products, from sunscreen to paints and coatings. If you look around where you are, you're going to find something made with titanium dioxide in it. It just is. And it prevents damage from sunlight. If I were depending on formulating a new, better than titanium dioxide for my company's product, I'd want a composition of matter patent to protect my unique material production. I'd also want to have a method of use patent that protected my proprietary application of that. So say I was making sunscreen, I'd like to protect the use of the technology so that only my brand of sunscreen, which contained my key ingredient, could be applied by a certain delivery system. Let's say a roll-on applicator. That method of use would be core to my technology strategy. And I might subsequently want to have a second method of use patent that covered, say, lip balm tubes. Might not be able yet to produce a lip balm product, but it might be my strategy to enter that market in, say, 2 years. So my technology strategy would match the market opportunities I envisioned from most accessible to least with the IP I needed and the R&D resources I plan to put against each opportunity.
Okay, that's really interesting. So Scott, didn't you also say in our earlier podcast that patents were expensive and that it might not be a good use of an entrepreneur's limited funds to acquire so many patents?
I did. And that's why a good technology strategy is important. Most times an entrepreneur becomes focused on securing their keystone patents or patent licenses. If they're the inventor of the technology, they can file with the US Patent and Trademark Office. Also, they can file an international patent cooperation. That's a PCT application. A PCT application opens the door for filing in 152 treaty countries, but eventually patent filings in specific countries will be required, and all that takes time and money. If your startup is a wellspring for invention, the company may get caught up in filing applications for a number of uses of their technology that they'll never likely commercialize. Or they may file for protection in countries that they have no real chance of selling into as a small business. Or they may set out to acquire license rights for technology applications they can't commercialize in the near term, and end up having to forfeit those licenses later on. Or they may be so focused on one particular field they use for the technology that they fail to recognize competitive threats from just outside their chosen application or use. All these considerations should go into preparing a company's IP strategy. And all of this should be articulated to prospective investors. So investors know the company has a solid understanding of the way business strategy drives IP strategy, which in turn drives resource requirement. Most entrepreneurs pitching for funding simply deliver a list of their patents and applications to investors, sometimes believing that the more IP they've collected, the stronger their case for funding will be. Personally, I'd rather see a short list of carefully considered patents than an IP estate containing 40 or 50 patents, most of which have little to do with the company's near-term development plan.
Okay, so Scott, I have to ask this question again then. If the odds for any one patent turning out to be valuable are so low, how can entrepreneurs know whether they should try and build their business on one or two or even 50 patents?
Yeah, there are several different models for performing intellectual property valuation. Getting into those would be more than we have time for today, and there are textbooks on that subject. There's a widely used one, for example, published by Wiley, and a technology entrepreneur would do pretty well to become familiar with the basics of IP law as well as IP valuation. But most entrepreneurs rely on an attorney, and the attorney can perform a patent search looking for similar filings. So if you're an entrepreneur inventor, by all means, have a patent attorney or patent agent involved in preparing and filing your applications. Patenting is just too important to a business to try to do it without professional help.
Scott, attorneys are expensive. What can an entrepreneur do on their own to become more strategic as they're thinking about IP?
Well, a good start can be going to the U.S. Patent and Trademark website, uspto.gov, and look at the Learning and Resources section. And drill down there into resources to information on what they call the 7 steps strategy. There's an online tutorial on how to perform preliminary search of U.S. patent and patent applications.
Okay, so that web address is uspto.gov/learning-and-resources.
Right. And searching on cooperative patent classification or CPC codes can be tedious, but it will reveal something about how competitive the patent area of interest is. Another way to navigate the USPTO website is to go to uspto.gov, and from there look up search for patents. That's in my, look that term up, search for patents. And that will get you search tools that let you run queries on patent applications and issued patents.
All right, so as entrepreneurs are searching the database, what would these entrepreneurs learn as they're searching?
Yeah, well, for starters, they'll learn what investors are going to discover when they run these queries, including a patent assignment search. So when I do due diligence, I intend to uncover all the published IP assigned to or applied for by the entrepreneur applicant. I'm looking to confirm that the patent is not held by an entity other than the company. Patents can be assigned. The assignee is the entity that effectively owns the technology. And you'd be surprised that we have companies applying for funding, yet we discover cases where the company doesn't control their own IP. If a company isn't the assignee, they need to disclose to investors the licensing agreement they've signed that describes the exact terms of use for the company's use of any intellectual property.
All right, so is there any way using these free search tools that an entrepreneur can get a sense for, say, how valuable their patent may be, at least in a relative way?
There are IP valuation tools that we use with our investors that perform text-based data mining to compare patent of interest against the universe of active patents and published applications. But those sort of analysis tools are beyond what most entrepreneurs will access. I only mention that because being able to algorithmically compare the relevancy of patent filings is powerful when negotiating licenses or trying to assess how much of a market a set of patent claims may address.
All right, so I think what you're saying is that information is power during these negotiations, right? And whichever side comes closest to guessing how much business value a patent represents will be in the best decision-making position. Is that right?
Yeah, as I've said previously, too often entrepreneurs feel compelled to acquire IP. This is often the case when a startup is licensing a technology to build a product. I could argue that it's better to walk away from a bad deal, even if it means losing the IP, than to acquire IP that turns out to be unprofitable.
All right, so better to walk away and come up with a different idea for building a company?
Patent attorneys pay to have software tools like the one I just described. So an entrepreneur's attorney might perform some of the valuation analysis for the entrepreneur, but then a budget-conscious startup entrepreneur, for one of those, one way to get a sense, at least for the novelty of a patent invention, is to look at backward and forward citations. So let me walk you through this. If I enter into a search engine, patents.google.com, right? I'm going to be taken to the Google Patents search engine. And there I can search by keyword, patent title, name, patent, or application number. What's nice is that when I open on a result, information such as the status and activity on the patent is clearly listed, as are the classifications by code and description. So then I can click on the classification code number and view other patents related by CPC code that may be competitors, right? So if I scroll down on the page after opening on a patent, I'll find a list of patent citations. And these are what are called backward citations. They're included in the patent application, and they're references to earlier patents that led to the subject's patent innovation. So a large number of backward citations means the subject patent involves evolutionary, not revolutionary technology. And a few backward citations indicates a very novel, potentially valuable invention. So below backward citations, I can view the cited by list of patent filings. These are forward citations. They're the applications that reference the subject patent and were published after the subject patent that we're evaluating. So few forward citations can mean that either the subject patent is newly published and researchers haven't had time to incorporate it into later work, or if the subject patent has been published for several years, it can indicate very little marketing interest exists in this innovation. The forward citation and backward citation lists also give indication as to what other companies or research organizations are active in the field. Google Patents is a useful way for entrepreneurs to find prior art and to get some idea about novelty and valuation, enough to let angel and early stage venture investors know the entrepreneur understands investors' concerns about risk related to intellectual property. So if you took nothing out of that long discussion there, and I apologize it went so long, but walking through that, remember Google Patents and figure out what backward citations and forward citations mean.
All right. And so, Scott, as we talked about in our last podcast, if the entrepreneur knows the way an investor is likely to look at the risks involved with commercializing technology, the entrepreneur can then address those concerns up front when pitching for investment. When preemptively answering serious questions shows investors that an entrepreneur was well prepared before asking for funding. And that always scores high marks, even with tough investors, right?
Yeah, I used to tell my sailors, preparation is the battle.
Okay, so until next time, Scott.
Until then.
Great. Well, we have reached the end of this episode of the 3 Steps to Startup podcast, brought to you by Tech Connect West Virginia, Innova Commercialization Group, and the West Virginia Jobs Investment Trust. It's our hope that you, the listener, heard something today that challenged you to think differently and provided the insights you need to take your venture to the next level. To check out additional episodes of the podcast or to learn more about the 3 Steps to Startup initiative, please visit 3stepstostartup.com. Thank you for tuning in, and we will look forward to being with you next time on the 3 Steps to Startup podcast.